Just get off here. Is that better?
Kevin, do you want to share your screen, Kevin? Do you have is there a purpose?
No, but we're going to, Boris, share the letter that you sent out today to the Supreme Court, and we'll give you a background after we start sharing that document.
All right. How do I share screen?
Go over there to the share screen button, mash it, and take the top one on the left and find your document.
Where's the share screen button?
Click the three dots on the top left-hand corner. Potentially, it'll say share screen, or sometimes it's on the bottom left.
Do you see where it says Part 1 at the top? Part 1 at the top, yeah. January 4th. It's those three dots.
Okay, those three dots there. Okay. And...
But yeah, we have some interesting information that we've been doing down in Florida. I've been assisting Boris and showing them
right
through the mire of how to get through there.
Oh, that's trippy.
Okay. Just go to your screen. Just go to your screen. Minimize that and go to the one that you want to go to.
Okay, so you can see it now?
No, there you go. There you go.
Okay. Now I just have to find the one I was doing
right here?
No, I'm looking for it again.
Oh, okay.
I closed it out, so.
Oh, okay.
The reprimand, right?
Yes. Well, the one to the court clerk of the Supreme Florida.
Yeah.
Okay, here we go right here. Can everybody read this?
Yeah, it looks good, brother. It looks good. We can see it.
Yeah, just cancel that out of there, Boris. There.
What?
Okay, there you go. Okay, you're just okay. So, what happened is that we're getting obstructed in Pinellas County by George Girotka, who is the presiding judge of the Chancery Court. After we sued 12 defendants in Florida, from the governor to the attorney general, Pinellas County clerk, Pinellas County sheriff, also Clearwater commissioners and Largo commissioners. They all, what they did is, instead of responding in their individual personal capacities, they used state offices, public resources, and employees to defend their case. Okay, and each one of them put in several, and by doing so, they essentially committed felonies doing so. Okay, and so the judge is trying to make sure that they don't get punished for doing so. And so what we did is we wrote, after we did the default judgments on them, which was subsequent to them defaulting, because none of them put in any answers. We defaulted them. Then we were going for execution, and the court clerk or the county clerk obstructed us filing our judgments in the county record, so therefore we can't execute the judgments against these people. So now what we did is we issued a writ of mandate to the Florida Supreme Court, and the court clerk says, well, we're going to construe your writ of mandate as an application for a writ of mandate, and that you also have to pay a certain amount of money. And so this letter, we composed this and sent it off to them. So let's start in on there, Boris, if you don't mind.
All right.
Dear Mr. Tomasino.
All right. How we come in is we always set our status in ranks, and it's always found within your state constitutions. And Mr. Tomasino, this is the clerk of the court, who decided he was going to take it on himself to charge $300 to get it in there. So
we say we're in receipt.
Yep, yeah, go ahead. Receipt your letter called Acknowledgement of New Case, dated December 29th. This is after. Okay, I also had to call up. We sent this in I got it on December 8th or 6th or something like that.
No, I thought we sent it in November.
I think it was December. I don't know. Anyway, they had it for a long-ass time, right? They had it for a long enough time for us to go, what the hell's going on here? Because they never responded back. We never got phone calls. And then we called up, and I said, where the hell's our Where's our writ? And they go, this one right here, we wanted to get full access to this. And I go, no, we want it in there because you got clerks down here refusing to file, taking filings off the records and not filing their own defaults in here. And we want this shit stopped because this is just simulation of legal process down here. And I go, and it's your environment. You're supposed to be ones taking care of this. So I want that thing taken care of. I want it before the judges. And that day, I get a letter back saying that they filed it in there as a writ of mandamus, and that we need $300. So this is our response to that, because we're already approaching this as, hey, we're the people, bound under Article 1, Section 1 of the Florida Constitution of 1838. Because that's the only one in existence right now. All the other Florida constitutions are illegal, are invalid, because they were forced upon the people. So 1838 was the last one that the people voluntarily entered into. And the story about that's on the Florida memory hole. But basically, they flat out tell us that 1868 it was all done by the will of Congress and at the hand of the military. So that's where they got the constitutions after, and that's when your deep state was put in and all that other administrative crap. All right, so thank you for your letter. Your letter appears to acknowledge our different ranks and statuses, wherein such status and ranks are set forth at the top of written mandate as follows. And we come in, we the people petitioners declare rank status for the purpose of the suit as follows. Where petition not bound by any law, rules, statute, codes, or regulations, or ordinance pursuant to Article 1, Section 1 of the Constitution of the State of Florida, because all freedmen, when they form a social compact, are equal, and each have inherent and feasible divides among those enjoying defending life, liberty, property, acquiring, possessing, protecting property, and a reputation, pursuing their own happiness. None of this is subject to codes, rules, laws, and regulations. And everybody, when they form it, are equal. Because we're all equal when we form. We're all equally free.
Okay, so how we find that is right here under Article 1, Section 1. All men are by nature free and independent, okay? And then if all political power is inherent in the people, then there is no exception to our public servants commanding their masters and telling them what to do and micromanaging them through statutes, laws, rules, codes, regulations, and ordinances, right? So that's how we present ourselves. Yep. Continue.
Because as one of the people under Article 1, Section 2, I've actually been chosen by people to represent properties for Florida, for people of Florida, whose political power is superior to his public servant, because the land patent we're operating from doesn't just encompass one dude. It encompasses a whole neighborhood.
More than a neighborhood, though.
More than a neighborhood. About 50 properties, 50 or 60 properties that we're aware of. And based on the size of the patent, it's probably more than that. And they're secured by Article 1, Section 26 and 27. 26, says frequent recurrence is the fundamental principles absolutely necessary to preserve the blessings of liberty. And 27 is this article remains in effect forever. And all laws contrary or to the following provisions, which is the rest of the Constitution of 1838, shall be void. So come in with we're beneficiaries of a trust whose beneficiaries are the successor and assigns of the land trust or the land patents, and the rights were already issued under the patents themselves as a contract between the United States of America and the one who received the land and the heirs and assigns. And all these guys take their office must abide by it because it's part of the act of admissions into the Florida the Union.
The Union of the several states.
Yeah, the Union of several states and the Confederacy. It's not just the Union; it's Confederacy and the Union of several states. So it shows you there's two different jurisdictions already inherent within the U.S. a Confederacy and a Union of states.
Right, which is the anti-federalists, right?
Right.
If we want to look at it that way.
Yeah. So we come in and the rights of the patents were pursuant to all constitutional enumerated rights, which are guaranteed within the patents and still protected under the 10th Article of Amendment, because that's any power not reserved and not given away is reserved to the people in the states. and the states never reserved any right to these properties. Now, part of their act of admissions is not to retain any rights to those properties. So
Okay,
we're here
so
to
let's
vote.
get down to reading let's read this to the people so they get an understanding of where we're
Okay.
coming from. Because it's
So
a good
Boris,
reprimand letter.
yeah, so we exercise the patent holder rights for protection, defense, security, and benefits set forth and identified in the patents under the Florida and federal constitutions, including inherent rights for all current successor assigns of the lands within the boundaries. And we exercise our political rights and ourselves and our assignees. The rights cannot be denied or restrained or struck out of public servants, will not be allowed, because the public servants have no rights. They have no rights. No emoluments, privileges, or honors. No hereditary. Just because they hold an office does not mean they get emoluments, privileges, and honors are conferred. They don't get anything. They get no rights conferred to them. In fact, they actually become subservient to the people, and they're trying to act as though they're superior. And they will not allow. And Florida original constitution monopolies and perpetuities are contrary and not be allowed. So the original Florida Constitution actually limits banks and corporations to 20 years. So when you go read it, just kind of look at that. And then they have the oath right here. They all take an oath. Public servants are created by the people to secure our rights, protect our property, and support and defend the federal Constitution and Florida Constitution. Then we go in and discuss how the 1865 was initially rejected by Congress, and that the ones after it are fatally defective because the General Assembly post-61 was never properly convened or seated and never had a full concurrence of 2/3 of each house. And that is defined as pursuant with the Florida Constitution 1838. What they did is they basically took everybody over 21 years of age and told them they could vote. And therefore, you have a bunch of federally enfranchised people voting in a federally enfranchised. So you have newly federally enfranchised electorate, then selected federally enfranchised delegates to frame a new federally enfranchised state constitution by congressional and martial edict, not by those authorized pursuant to the Constitution, not by the free will of the people.
Let's explain something. At the founding of our country, a man could not vote, and women. A man could not vote unless he owned land. Okay, and he was situate within the area in the vicinage of where he was going to take public office. What they did is they removed that requirement, so any yahoo that doesn't have a vested interest in the community couldn't do anything, because why should we have an outsider come into the community and tell us what to do, right? That was the reasoning behind men needing to own land before they could vote, because if they had no vested interest in it, then they don't have any rights to tell the rest of the community what they can do with their land or not. So what they did is they eliminated the land requirement and allowed everybody to come in and vote, and therefore it's destroyed the sovereignty of the European society, which was built here and modeled, which our society was modeled after here. So essentially, if you don't have land, you don't have any sovereign people here. You know, I mean, yeah, you might have sovereign people, but with no land, you don't have any private property rights. And the first plank of the Communist Manifesto is that there shall be no private property, and they shall abolish all of it. So it's very important to see these aspects here before we get too much further into really what's going on. And if Article 1 of the state constitution says all men are by nature free and independent, have certain inalienable rights, among which are acquiring, possessing, protecting property, and seeking safety and happiness, where is the exception to the motor vehicle code, the penal code, government code, statutes, ordinances by the city, or anything else? Well, they just simply don't exist, and they don't attach to the people. So unless you understand the Constitution at this refined level, you don't have any rights. Okay, so now if we take Article 1, Section 2, all political powers inherent in the people, Well, where is it saying that the servants can tell their masters what they can do and what they can't do? Well, there is no exception to that. So it's like I've won many cases just on using those two sections out of Article 1 of this state's constitution and many others where I've helped people around the nation here, you know. So, and mostly all of them won, except for 7 out of about 100 that don't listen and they want to do something different and they think that what I'm saying is wrong. So therefore they lose their land, go to jail or whatever it is, right? You know, and lose to government every time. So it's important to get, you know, your own personal knowledge about what your rank and status in society is and what everybody else's rank in society is, whom you may be dealing with, right? So we first have to understand that first principle. What's my rank and status? Oh, I know what it is. My rank is king. Okay, what's your rank and status? Oh, you're one of the subjects. Okay, so, and if you understand it to that level, no man can really mess with you, whatever they call them, right? So go ahead there. Anybody got any questions about that?
Well, actually, I got a little comment, Kevin. This is Pops. You and I haven't talked in a long time, and I got to say, hey, brother, how you doing? Love you. Miss speaking with you. And for everybody listening, I have to say that this is one brother that, man, you talk about a memory like a steel trap between him and Boris and a couple others. My God, these guys can remember every freaking detail of shit that they read freaking years ago. And the fact that you and Boris are hooked up doing some shit right now, oh, man. Y'all gangster. Y'all straight up gangster. I applaud you guys. I love you guys.
Oh, thank you. Thank you.
Yeah, thanks. All right, so this is where we come in. Is we come in that way, and so far that they've shown us every hand that they have, which is all they have is their administrative bullshit they hide behind.
Well, no. What they got is their predilection to commit
their
crimes.
predilection. Yep, their predilection to commit crimes.
You know, and they don't have any second thought about it either. They just do it thinking that it's okay for us to commit crimes.
I mean, hey, it's at the point where the attorney that is interfering on DeSantis and Moody's behalf has actually twisted the whole case to turn it around and to think that we were actually suing them in suing the official capacity, and they're trying to use that procedure against us when the procedure in their statutes and codes and everything is once they did the acts they've done, they're outside. Yeah, while in office, they're outside their office. They don't have any. They breach their oath. They're enforcing communism.
Beyond the bounds of their jurisdiction.
That's right, and the code itself, the one they're actually using. There's another part of it that says, "Oh, by the way, when that guy does it outside of scope of his office, all this other shit doesn't apply."
Right, and it's just another subsection down. Yeah.
Yeah, it's just like a subsection down. So they're trying to keep it on a level that they control through their administrative process and procedures, but they didn't realize that. I don't think they even realized or even read the law that says, "Hey, man, when you step outside that, you're just a dude."
Well, see, they know it. They're doing it willfully and intentionally is what they're doing, right? So that means they've committed like 12 felonies, at least.
At least the judge has committed, well, think if we go that route, it's like 24 because it doubles every time it happens. So the attorney did it. The attorney filed the paperwork. So just at the order of DeSantis and Moody. So when the attorney committed the crime, DeSantis committed the crime, but did it 3 times. Because he did it by enticing her, enticing her to do it. But then also, since she was acting in his name at the time, he committed the same act she did. So he commits 3 times the amount of crime that she did. So the judge has committed 9 times the amount of crimes as that, because it's exponential each step down the line. Do you see it? It's 1. Then he committed 3. 3 became 9. 9 becomes 27. It just keeps going down the line.
Right, and especially if, like, for example, Clearwater's commissioners had the city attorney write responses for 5 of them, right?
Yeah.
So that's five separate acts of violations of oath of office, which is a felony, 5 obstructions, 5 misuse of office, right? So you see how
the attorney committed it 5 times, but that judge committed it how many? 15.
Which judge was that?
The same judge.
Name.
So the judge in our case, Judge Jericotta, or whatever he called it.
Jericotta.
And I got his name for you today.
What's that?
Yeah. I got his address for you.
Yeah. So.
Oh, that Mark.
We got that. So. Every time, every level we go with this, it just increases the amount of damage they're doing to themselves. Because we turn this into a tar baby.
Yeah, every time we touch
we came at this as, hey man, we're challenging your tax under your own codes, which is, you're saying we have a right to go to Chancery Court to do that. So we went to Chancery Court and do that. And by the way, to avoid the multiplicity of suits, we're going to challenge his lien in here too, because we also do that in Chancery Court. And the moment we threw it in there, from that moment forward, we've gotten nothing but fighting from them. And nobody's wanted to answer.
They've always been off point and frivolous,
Yeah.
And the thing is they came in after default judgment. So it's like now they're trying to come in with answering and pleading and doing motions. Well, we're past that now. Yeah. And the jury
already had their chance.
The jury was unanimous in deciding against them on all the counts that was specified in the petition.
Yep. So now what we've done is we've filed a petition with the Florida Supreme Court to force the clerk to file the documents and force him to open up the court to us so we can enforce our judgment. And now they're trying to come back with, you owe us $300 in order to do that. And we're coming back going, no. You didn't address us in our proper, so we require him, John A. Tomasino, to now in the future must address us according to our ranks and status is similar to persons in the military, aka general, colonel, captain, lieutenant, private, etc. And they have failed to acknowledge that state business does not require the king, aka the people of Florida, to pay our public servants, because that's what we're doing. We're not doing this as a private matter. We're doing this as a matter that affects many people, many of the inhabitants of Florida.
Thousands of people.
Yeah, thousands of. We found there's 1,000 damn patents in Hillsborough County that have been separated from the record, and that's just one county in Florida. How many others are like that?
Boris, we found a new way of enforcement. As soon as you get your summary judgment, call Duns and Bradstreet. They'll ask you to fax over your summary judgment, and they'll put a lien against their Duns number for the state and the county, so they can't get federal block grant funding, which means they can't make payroll.
Well, we've got certified judgments against that.
That's what I'm saying. If you send it over to Duns and Bradstreet, all you got to do is call them and say, we have a perfected security interest in the state in the form of summary judgment. And they'll say, okay, fax that over to us. Within 15 minutes, they will put a lien on that Duns number. And once they have a lien on that Duns number, you're the only one that can remove it. They will call you and they will settle with you.
Okay, well, that's good to know.
We found an expedited way, instead of trying to go through the courts to get, a supplemental hearing to do writ of bodily attachment, garnishment, all that stuff, writ of execution. We just go directly to Duns and Bradstreet, and they put a lien on that Duns number, which means the federal government can't give federal block grant funding anymore, which is how they float everything and pay state government officials and the trustees. And they'll call you within an hour or so. They'll call you and say, hey, how can we remedy this? Because it's too much work for them to foreclose on their corporation or go into bankruptcy, create a new Duns number, and roll all the assets over. It's entirely too much work. And so what they'll do is they'll settle with you, because they can't remove the lien. You're the only one that can remove it. And what they'll ask you, what the Duns and Bradstreet will ask you to do, is fax over your perfected claim, and then they'll go ahead and put the lien on there for you. And it's such a beautiful process. When the gentleman showed it to me, I was like, "Fuck, this is genius. How'd you stumble across this?" He goes, "I just got lucky. Met the right guy at the right time." So there's another option for you instead of arguing in their venues. And what he pointed out, and what I quickly gained to realize, was administration is under the executive branch, not the judicial branch. Everything after the Act of 1871 was coupled underneath the executive branch with the Reorganization Act. So they're operating outside the official scope of the judicial office. And so the exclusive jurisdiction of equity is actually in the judicial branch as an Article 3 court, and they do everything they can to prevent you from getting in there. So in lieu of that, after you execute your private administrative process, that's considered a perfected judgment. When they didn't respond, they acquiesced by tacit agreement. Simply get a hold of Duns and Bradstreet and go, "Yeah, I've got an interest in the state's Duns number. I've got an interest in this county's Duns number. I'll go ahead and place a lien on them. Here's my perfected interest." And they'll go ahead and do that for you. And then just sit back and expect a phone call from either the Attorney General or the Governor's office saying, "Hey, we'd sure like to settle this with you because we'd like to get back to business."
Pretty freaking amazing. That's incredible, Derek. Hey, listen, we're at the 8:00 hour. I just want to make sure you start a little bit early. Boris and Kevin, you had joint group there, togetherness. Right. What do you got? Do you want to wrap it up? Do you have? Do you want to bring this thing to a close? I know that you can't speak like a full exposition on your subject matter in a 25 minutes.
I wasn't even expecting to speak this much on it, so.
I would like to, it would be a great chance to wrap it up, if you don't mind, if I can address one of the key elements in your process, references the original Constitution versus the constitutions thereafter. And if I could just ask, I know that Kevin speaks in the past. I know that's his subject matter. Would you like to end on a little, just a blurb about why you go back to the original Constitution before we get to our next speaker? Kevin, that was for you.
It was never repealed.
The what now?
It was never repealed.
Yeah, the Constitution of 1838 is still in effect, at least in Florida, because that's the one that they were admitted on in 1845. 1865, the people had rewritten the Constitution and gave it to Congress, and Congress said hell no, and they rejected it, and then reinvaded Florida actually, and re-put the military in place, and then only by the agreeing to the Constitution Congress wanted Florida to have were they allowed back into the Union. So the Constitution in 1868 was put to a vote of the people, but it was put to a vote of people who weren't properly convened under the 1838 Constitution, which is all white male inhabitants who are free over 21, who own land and that kind of stuff. So therefore, they didn't even amend the Constitution. It was all done. It was at gunpoint. You cannot have something be done at gunpoint and move on from that point, because then everything has to be under gunpoint.
That's exactly what the Magna Carta, because they put a sword to the king's throat and said, "Sign it," and the Vatican.
Yeah, exactly. So every time it had to be under a sword. You can't really do that. You can't not really do that with a gun. So it's only by the people in their lawful, willful capacities does the states get made. That's the purpose of the states, is so people can get together and agree on this. This is what we all agreed upon, not we agree upon, no, we're going to come down and say we want you to be this because we want everybody to be enfranchised. No, that's not the way it's supposed to work.
By the Charter of the Forest has way more weight than the Magna Carta. The Charter of the Forest was voluntary.
When they came in under Reconstruction, they just created a parallel government. They didn't get rid of the old one.
They put two governments in place. They put one that was already there, which is all their territorial governments, and then they put a military one that's under a what do they call it? There's three forms of martial law in this nation. You got military law, which is bullets are flying, bombs are dropping, military's in charge, you get out of their way, right? You got martial law, which is what the Congress is running under in their little territories, and then you got what you got is martial law proper, which is there's not by Congress, but it's here because there's not sufficient protection for property and person, which is what when you look at the definition, you go right back to the Attorney General opinion for 1868 Reconstruction, and you see that whole document was about voting. The same shit they're arguing about today, they were arguing about back then. Same fucking bullshit.
Michael, I posted in your channel administrative office AO091 to go after the actors who are acting outside their office treasonously. The AO091 goes to the JAG, and then the military takes the information and they do their own due diligence.
Now, how do you get it to the JAG?
It's a longer process. I'll talk to you later about it. But then the military comes in and judges disappear.
Okay.
So some of these bad actors in office, when they're acting in treason,
was that you, Smoking Baby, that mentioned the Charter of the Forest?
No, the Charter of the Forest was Derek.
Oh, okay, Derek.
But the reason
why I
the
mentioned
JAG
that
gets
is
involved
because
is
so
because
few
the
people even know about that, but I do believe he's right because, yes, that was voluntary, not in the tip of a sword.
From my understanding, they're actually supposed to guarantee the people's right or the state's right to a Republican form of government must be guaranteed.
It's still there.
My understanding of that is that it doesn't mean the state is protected by that guarantee. It's just the Republican form of government is collected by that guarantee. So when they're over here doing their communist form of government, they're actually invading the Republican form through whatever offices they are. So therefore, you have a piracy and invasion coming in. So I can see that being like the militia, the people, coming in under Article 1, Section 8, Clause 15, to help repel the invasion and suppress the insurrection and execute the laws of the Union and give it over to the military as a trustee to do so.
Well, the military, we do that through the AO91 to get the military involved.
Yeah, that's what I mean. But who do you give the AO91 to?
The JAG. We'll talk about it later.
Yeah, ladies and gentlemen, we got a lot of speakers here that are lined up to speak, but there is the AO91 process that's on. We Are the Law. Michelle does a class. Smoking Baby knows the AO91, Administrative Office 91 process, where you can look up the form yourself. Get in touch with
look up the form. I just don't know who to give it to.
Well,
and I know that there's not one office for everything.
We'll keep sharing that information. We'll put that in the group there. Let me just before we get off track, let me make sure my next speaker is up and ready, and then we can continue this conversation if for some reason, because we've bled over into the 8 o'clock hour. Leo, are you on? I tried to send you a few messages and try to call you. This is your time slot.
Can you hear me now? I'm here.
I can. Well, ladies and gentlemen, this is a new speaker to the House of Prayer, someone from up north of the so-called American line there in Canada. And I want to introduce to you Leo, who I have understood is operating his understanding of providing liberty and freedom using the common law. Leo, I don't have a whole lot to say as far as introduction to you because we just met, but I invited you to this community. As you can see, it's an intense crowd, and there's certainly going to be people here that would give you a run for your money if you step out to the right or to the left. But but here you go. I'm giving you the opportunity in the House of Prayer to tell us what you've been doing. Leo Cody.
Thank you very much, Daniel Johnson. And yeah, really, what an impressive bunch of people. Wow. I give kudos to all of you for all the hard work you've done over the years. I thought I was doing hard work. You guys just bury me, really. So anyways, so I decided to come on because people always have a curiosity of common law, and I've been using it, I would say somewhat successfully. I've won several different cases to the courts. And so I've tried to get my video on here, by the way, but I guess I haven't activated it. Can any of you guys see me out there all right?
You haven't put your video. Are you trying to do your face, or you're trying to
Just my face, yeah.
Well,
So I'm
hit
not
the
really-
little video button to the left of your green button there on the bottom.
Yes, I've done that, and I've hit share, and nothing seems to happen. So, pardon my. I'm not very computer savvy, as you're discovering.
Well, does anybody? I wonder if anybody has their video on. I noticed earlier one of the speakers had his video going. If anyone has their screen share still on or the video going, please turn it off, and maybe we can try it that way.
Okay,
There's two check boxes.
Who's on?
There's a checkbox when you want to share video.
Okay, yeah, I've checked on video, but it's not activated, and share comes up, and I hit that. So pardon me, guys, I'm not very good.